The Reserve Bank of India views virtual currencies as a high-risk activity. There is no coherent regulation of cryptocurrency in this country.
Regulation cannot be done by any one country singularly. It has to be a collective action because technology doesn't brook any borders.
Whether it is market manipulation, financial crimes, money laundering, terror activities, or the feared threat to the existing financial systems, India presently lacks a comprehensive regulatory framework that specifically is designed for virtual currencies. Whilst all nations across the world recognize the threats posed by cryptocurrency, these threats do not overshadow the benefits of digital currencies. India seems to be preoccupied with its threat-based perception of cryptocurrency, which seems to thwart any enabling regulatory measure. India presently lacks a comprehensive regulatory framework that specifically is designed for virtual currencies. Virtual currency is not recognized as legal tender, nor is it recognized as a medium of exchange in India. In 2022, the government proposed that there should be a specific legislation for the regulation of cryptocurrencies in India. The Cryptocurrency and Regulation of Official Digital Currency Bill was drafted, but the bill hasn't been tabled yet and has not seen the light of day. The Reserve Bank of India, like most traditional central banks, views virtual currencies as a high-risk activity. Whilst we do not have a regulatory framework, we also do not have guidelines or rules that govern the resolution of disputes or disagreements that emanate from cryptocurrency activity. India, on the other hand, has heavily taxed cryptocurrencies after classifying them as virtual digital assets. Apart from certain basic KYC requirements, there is no coherent regulation of cryptocurrency in this country. But there are many countries across the world that have successfully and proactively regulated cryptocurrencies. These include Dubai, European Union, and the emerging regulations in Hong Kong and Singapore. These international examples also point to the fact that most countries have accepted the reality of cryptocurrencies instead of denying it. Whilst all nations across the world recognize the threats posed by cryptocurrency, these threats do not overshadow the benefits of digital currencies. At any event, the regulatory remedy cannot be worse than the malady. Governments across the world have been worried about the potential misuse of cryptocurrencies, especially against national security. Whether it is market manipulation, financial crimes, money laundering, terror activities, or the feared threat to the existing financial systems, governments are actively working to combat the threat posed by cryptocurrency. Recently, a top official from the Reserve Bank of India reiterated the stand of the central bank. RBI continues to believe that cryptocurrency is a threat to the existing global financial system and could lead to a global crisis at some point. India seems to be preoccupied with its threat-based perception of cryptocurrency, which seems to thwart any enabling regulatory measure. Crypto has been viewed with a sharp critical lens, almost equating its usage to money laundering and financial crimes. This is starkly different from the expanding reality where Indians are investing in crypto and view it as a medium to grow their money. With a phenomenal increase in the number of Indians using or trading in cryptocurrencies, the need for a regulatory regime that is both proactive and enabling has become a necessity and is not a choice anymore. Many countries across the world have taken the leap of faith. The first example we should look at is Dubai. Dubai has emerged as a hub for various crypto players, boosting investments and serving as a destination for institutions and businesses who want to invest in cryptocurrencies and virtual digital assets. Let's look at the regulatory mechanism that Dubai has introduced in 2022. The Dubai Financial Services Authority kickstarted the crypto token regime. This regime establishes a comprehensive guidelines which are aimed at safeguarding the present and potential users of financial services pertaining to cryptocurrencies. Under the Dubai regulatory framework, there are certain crypto tokens that are recognized by the Financial Services Authority or DFSA. Only those tokens can be utilized for financial services and associated activities which are vetted and approved by the authority. Recognition by the country's regulator is granted based on meeting specific criteria that have been outlined transparently. The DFSA assesses various crypto tokens against transparently laid down criteria and may grant or refuse to grant recognition. The framework may or may not give a certain degree of control and regulatory oversight to the authorities. But it has certainly enhanced transparency, mitigated risk, and brought in a certain level of integrity to the crypto token system and the related financial services within that jurisdiction. Now contrast that position with India. Right now, other than a KYC requirement, there is no other method by which a regulator is vetting bitcoins or any other cryptocurrency which are being purchased or traded by Indians in the Indian market. The other example to look at is the approach by the European Union, which initiated the markets in crypto assets or MICA regulations. The European system differentiates between various types of crypto assets, providing regulatory requirements for each category of those assets. The approval of MICA by the European Parliament marks a crucial step in establishing a comprehensive regulatory framework for crypto assets in the European Union. MICA introduces a tailored licensing system for crypto assets and services, and it allows passporting of these assets and services across all 27 member states. This move is expected to streamline the regulatory process and promote cross-border activities within the crypto industry. This move promotes certainty, consistency, and confidence amongst the market players. MICA differentiates between various types of crypto assets. It provides specific regulatory requirements for different categories, recognizing their diversity and their unique use cases. The MICA regulations define crypto assets as a digital representation of value or rights that may be transferred and stored electronically using distributed ledger technology or similar technology, which is blockchain. Utility tokens, asset referenced tokens or ART, and e-money tokens or EMT are three categories recognized by the European Union. A utility token is really a type of a crypto asset that is only intended to provide access to a particular good or service which is provided by the issuer, whereas ART or asset referenced tokens are a type of crypto asset that is electronic money token that aims to maintain a stable value by referencing it to another value or a right or a combination, whereas e-money tokens is a type of a crypto asset that purports to maintain a stable value by referencing the value to one official currency. Interestingly, non-fungible tokens or NFTs as we know them are kept out of this regulation owing to the continued innovation in that area. NFTs are yet to mature, and you let them mature before you regulate them seems to be the agenda. The EU regime has been able to strike a fantastic balance between consumer protection and industry growth, providing clarity and certainty for entrepreneurs and investors in the crypto space. There are other common law jurisdictions too, where the courts have emphatically held that cryptocurrencies can be classified as assets and can be held in trust. Let's look at the example of New Zealand. The courts in New Zealand have concluded that cryptocurrencies meet all criteria of property in the traditional legal sense or in the common law sense. It is an identifiable subject matter. It is identifiable by third parties. It is capable of assumption by third parties, and it has some degree of permanence or stability. Therefore, a cryptocurrency is property. The court therefore concludes that cryptocurrencies can be subject to a trust, and courts in New Zealand have recognized cryptos to have an element of property rights to them, which means that they can be held, bought, sold, etc. Similarly, Singapore law recognizes crypto assets as property which are eligible for trust arrangements. This landmark ruling of the Singapore High Court clarifies the legal status of crypto assets and allows parties involved in crypto cases to apply traditional common law principles for asset protection. India, unfortunately, has miles to go before it can reap the benefits of virtual digital assets and cryptocurrencies.